Thank you for everybody to attend to this conference. This is our second edition. My name is Karine Gentelet. I'm associate professor of social science at Université du Québec en Outaouais. It's in Canada. And I'm also a holder of the chair Abeonas ENS Obvia on artificial intelligence and social justice. And I'm co-hosting this event with my colleague Céline. And Céline, I will let you introduce yourself.
Hi everyone, my name is Céline Castérenard. I'm a law professor at the University of Ottawa, Civil Law Faculty, and I hold the chair on accountable AI in a global context. And we are very glad to welcome you in this second edition, and thanks to Amber to be with us. And maybe Karine, you will explain the way we plan to process, or maybe I just want to mention the fact I will collect the question and after the talk of Amber, and I will ask him the question. So don't hesitate to put your question in a Q&A session.
Yeah, you have a little box on the right of your screen, so don't hesitate. But before I begin, and as I am hosting this event from Montreal, I wish to recognize that we are on a millennial indigenous territory, a place of meetings and diplomacy between indigenous people, as well as the Treaty of the Great Peace. I therefore thank the Kanien'kehá:ka Nation for its hospitality in this unceded territory. So yeah, so the presentation, Amber presentation will be of 45 minutes, and then it will be followed by a period of questions. So as Céline mentioned, you can write your question on the box. About our presenters, our speakers, sorry, let me introduce you. We are really very delighted that he's accepted our invitation. I know he's a busy man. I would have had that he come from far away, but no, because we are online. So, but anyway, Amber Sinha is Executive Director of the Center for Internet and Society in India at CIS and not CESI, as I was intended to say. Amber has led projects on privacy, digital identity, artificial intelligence, and misinformation. And I think he's in 2019, he released his first book. Maybe he will talk about that. And the title of your presentation, Mr. Sinha, is The Need for a Responsive Regulatory Strategy for Emergent Technology, a Blueprint for an Evaluation Framework of Governance. So, Mr. Sinha, you have the floor. It's all yours.
Thanks a lot, Karen. Thank you so much for the very kind invitation, for giving me the opportunity to address a talk on this issue. And so when we started discussing this talk, I think our conversation also have gone through various stages. And so there were a gamut of things that eventually we decided that we would touch upon. To begin with, I think what we had discussed was that we would focus more on machine learning and artificial intelligence. But I think given the sort of issues that all of us are facing globally right now, given the focus on the COVID-19 pandemic, what we decided was to broaden our scope a little bit and look at what kind of regulatory theory issues are posed by emergent technology and how they are being deployed also in the context of the pandemic. So I think we would cover a fair bit of ground over this talk, and what I want to begin with is by talking a little bit about certain trends that we see in India, in large parts of the global south, but also I think in large parts of the world otherwise as well, in terms of how technology has fashioned itself in the last 2 decades or so, and in what ways regulatory interventions have had to reorient themselves in response to that. And broadly within that larger context also, we'll briefly take a look at some of our work around technological solutions that have emerged in response to the pandemic, and how we may evaluate those solutions as well. So I think one large trend that we see emerging across various kinds of technologies that have become very, very important, let's say, over the last decade and a half. So whether it is big data, whether it is the emergence of machine learning and artificial intelligence, whether it is digital identification technologies, and whether, I think more recently, we've had contact tracing and immunity passports and things of that nature in the context of the pandemic. So I think the thing that we will focus on to begin with is a trend that I want to highlight, is that there is a certain way in which governance frameworks as well as regulatory frameworks have traditionally existed, let's say, over the last century or so. And I think since the 1940s or so, most of the governance frameworks that have spread globally, the conversation largely begins with human rights. And then it flows into other domains such as public interest, national interest, and things of that nature. But human rights has remained pivotal to that conversation. And what I wanted to explore first was the manner in which these technological developments impact that discourse. So I think the argument that I'll try to make today is that any discourse on human rights begins with the idea of what we call the informed self. And we'll discuss the informed self in some detail. And what I will then talk about after that is the gradual move from the informed self to the quantified self that we have experienced in the more recent past. So if we think of most theories about how we understand human rights, it sort of begins with the idea of certain inalienable rights, and largely they take a top-down approach, right? So this approach always begins with the identification of some kind of overarching principles. So now whether those principles are, whether it could be something like the principle of utility that John Stuart Mill spoke about, or it could be something like Immanuel Kant's categorical imperative. And this sort of philosophy of talking about human rights takes this idea where you trace the existence of human rights to human agreement in some senses. There is a human agreement, and in most jurisdictions that agreement in the last sort of century has taken the form of some law or constitutional framework which recognizes that form of human agreement. So this is what Jack Donnelly, I think, spoke of as a kind of international normative consensus, or a kind of emergent political practice that was very much at the center of all regulatory solutions that we came up with. Now, the primary criticism of this kind of an approach is that it works only when there is the primacy of a very state-based system. On the other hand, if we think of a bottom-up approach, the kind of approach that has been argued by people like John Tassiolas or James Griffin, there the idea is that human rights are very much a part of our actual social lives. So these are lives of politicians, lawyers, social campaigners, theorists of various sorts. And these are often central players in sort of articulating a conception of human rights. And that arises very much from the virtue of being human. Griffin spoke of this concept, what he calls as personhood, which is dependent upon human rights as protections of our normative agency. And if we think of normative agency as a capacity to choose and to pursue a conception of what Griffin calls the worthwhile life, then what we need to also understand is that this agency is not simply about ability to perform certain actions, but a kind of an active decisional autonomy. Now, as protectors of human agency, there are various stages that human rights, one could say, performs. The first stage could comprise of our ability to consider our lives as a whole and reflect upon what makes our lives worthwhile. And then from there to the ability to make decisions about the sort of life we want to lead. Now this ability to take decisions must necessarily, in order to exercise this capacity, we must have certain tools at our disposal. So the pursuit of the conception of a worthwhile life requires skills, resources, and support that we need to enable us to exercise that autonomy. And there, the idea of the informed self emerges from. Now, without having a minimum amount of information about the ecosystem that we operate in, it's just not possible to be in a position to exercise that kind of autonomy. So that information very much becomes a prerequisite for us as individuals to make real choices and be autonomous. So more and more as we talk about the specter of technology that surrounds us, and of technological determinism in the way that it dictates our sort of behavioral selves, the idea is that autonomy being compromised to a certain extent. And if I were to play the devil's advocate, I would say that humans never have had that sort of autonomy. So if we take the example of something like patient autonomy in medical practices, traditionally, patients are often too stressed. The explanations that are given by medical professionals are too brief. They could be too technical. And based on that, a real choice often cannot be made. So that has, I think, traditionally been the idea of informed consent that we speak about across various disciplines. Sort of patient autonomy has been a classic example that has been presented as often the failure of an application of that sort of informed consent. Now, our capacity to be able to make an autonomous choice depends very much on our ability to come to some bare minimum understanding of the environment that we engage with, right? So if we take more immediate examples, users who are unaware of how their personal data would be used by a data controller, by a service provider, and what other data sets it may be combined with, which could lead to inferences being drawn about them, which could lead to decisions being taken for them as well as about them. In the sort of complicated web of data ecosystem that we exist in, it can be argued that we don't have the requisite amount of information in order to make any form of autonomous choice. Similarly, if a citizen who has a right to free speech, but no publicly disclosed avenue for redressal, may not be able to do much with such a right? So I think in my book, The Network Public, which even the title of that book is a homage to a book from 1925 by Walter Lippmann called The Phantom Public. In that book, Lippmann contemplated man's ability to perceive and accurately comprehend the world. And overall, that book, written about 100 years ago, was fairly pessimistic about the idea of the public as understood in theories of democracies, as whether the public was sovereign or whether the public was a competent citizen who could make rational choices. And more what we see is that there are various manners of black boxes that exist in the systems around us, and they compromise the ability of the public to make autonomous choices, and that limited capacity has very clear implications for the manner in which the rights framework that remains dominant in any kind of discourse around governance and how that often fails. So in terms of moving from the idea of informed self to a quantified self, there are a few different aspects that I wanted to cover. The first kind of trend that we see is the trend of what we know as big data. And big data has various kinds of definitions. A lot of people define them in terms of the 3 V's, which is velocity of data, the volume of data, veracity of data. For me, the key thing, the 3 key factors that have made big data possible and that characterize its kind of everyday existence. The first is what we see as increase in computational capacity, right? So most of the algorithmic frameworks that we talk about that relate to this black box that I mentioned, these are not mathematical models that are new, right? They've existed for the better part of the last half century. But what has happened in the last decade is we, for the very first time, we have computational capacity. Machines have that sort of computational power to actually implement these mathematical models in real life. The second key trend is the availability and affordability of storage capacity, right? So data collection is an exercise that has happened at all points in history, but data storage has always been very expensive. So even about 30 years ago, when data about citizens was collected, when census surveys were done or other forms of data collection was carried out, as soon as the primary purpose for which that data was collected was met, there was a high incentive to delete that data because storing that data was so expensive. So now the availability and affordability of storage capacity has increased dramatically and continues to increase dramatically in that sense. And that makes it possible for us to continue to hold on to that data. And the third kind of trend that we see is computational devices that we use in our everyday life. So personal computer, personal use devices, cell phones, and those, as we interact with them, we for the very first time have devices which are capable of capturing an enormous amount of data in real time and that relate directly to human behavior. So this is one sort of large kind of trend that we see that is pivotal in the movement from what I call the informed self to the quantified self. The second pivotal thing is that of digital identification. And that's a term also that gets used a lot, digital identity. And essentially what that term means is any kind of identity system in which the processes of identification, the processes of authentication, and the processes of authorization are all done digitally, essentially transforms into a digital identification system. So what that means is the process of enrolling yourself into that system is done digitally. Then once you have enrolled yourself in that system, there are certain ID credentials that you've been provided with, right? So if we think of Facebook login as a digital identification system, then there is a process in which I can use my email address to create a Facebook account. That process of identification happens digitally. Once I have created that process, then I can use my Facebook login to authenticate myself with various service providers on the internet. And there, in order to authenticate myself, I have to provide my password. And then the third process is once I have authenticated myself, I can authorize transactions. And when I say transactions, I don't necessarily mean monetary transactions, monetary as well as non-monetary transactions. In terms of my dealings with third parties, in terms of my being able to identify myself to them and use their services in many ways, those authorizations are done via that login. So I think, and then a similar kind of concept applies when digital identification is also used by the state. So for instance, the Aadhaar ecosystem in India is very much a digital identity system where you are first able to enroll in that system. And unlike Facebook, which is self-asserted, this is not self-asserted, right? So they'll have to verify whether you are who you claim to be. And once you've enrolled in it, then you have ID credentials in the form of biometrics. And you can use your biometrics, or you can use a mobile PIN associated with your registered number to authenticate yourself and authorize transactions on your behalf. So more and more, where digital identity plays a very pivotal role in this sort of movement towards becoming more and more quantified, is that all our interactions, all our transactions, all our dealings, both with the state as well as private parties, are intermediated by that digital identification technology. So there are, in certain cases, you have unique identification system, and where essentially every individual has one ID, and that centralized system is what you use to identify yourself with a variety of stakeholders. So those are, I think, two key factors. And then the third thing that I wanted to talk about, that is very much related to the idea of quantified self, is this sort of specter of machine learning algorithms that we see more and more. So if we look at the word algorithms, from being very much an abstruse mathematical terminology, which was used primarily by computer scientists, not very long ago, it has rapidly become a part of mainstream discourse, right? Now, the definition of an algorithm, the most sort of concise and accurate definition that I could think of is by the computer scientist Donald Knuth. And he responded to various sort of formulations of algorithms as a formula. And he said it's not a formula, but rather a word computer science needed to describe a strategy or an abstract method for accomplishing any task using computational devices. So in effect, an algorithm is a sequence of instructions that tells a computer what to do. And this is typically done by switching on and switching off billions of tiny transistors within a computer system. And algorithms are generally meant to be an exacting standard, right? So they have to be extremely precise and fairly unambiguous recipes, so to speak. And as algorithms get longer, as they get bigger, more data intensive, they get more and more complex for human comprehension. And it also becomes harder and harder to correct and fix them. So this is where machine algorithms essentially comes in, right? So instead of conventional algorithms where you have an input and an algorithm processes the input data into the output, machine learning algorithms have essentially data and the desired output as the input. What you feed into the computer is not a precise set of instructions, but the data itself and a model of what kind of output you're looking for. And in fact, the output of this process is the algorithm, the specific algorithm itself, which will turn the input into the final sort of output. Now, the idea that as more and more data is fed into the algorithm, it will become more and more accurate, because which is based on the assumption that the more data there is, the more accurate it could be, because the more sort of bases it has covered, and the more the algorithm can learn as a result of that. So as we see the greater use of algorithmic systems, and they control and govern various facets of our lives, algorithms now have very public-facing identity, right? And that public-facing identity was not, is often sort of positions them as efficient, as powerful, as valuable and objective, as opposed to, the predecessors, which were, biased human decision makers. And this is what Kate Crawford and Dana Boyd called the mythology of big data. And what I was talking about earlier, the more data you have, the better the algorithm will be, is this idea of data fundamentalism. And largely what it means is that numbers don't lie and always represent whatever we understand as the objective truth. Now, the fallacy of the idea of objectivity of ML algorithm and big data is now well documented, right? So we have various examples of discriminatory, inaccurate, and exclusionary uses of machine learning within our midst. But the aspect of what complicates the whole thing even more is what Pedro Domingos in his book, The Master Algorithm, when he explains learning algorithms as having remained largely opaque to observers, right? That's the bit which relate most clearly to our earlier discussion on the informed self. Now, if you're processing between terabytes of data as being inputs into a computer system, and the algorithm arriving as insights based on them, as a result is a complete black box. What you're left with are fairly inscrutable processes, right? And those inscrutable processes then deliver unexplained outputs, which essentially govern our lives. And our lives, while they are being quantified, while they are being measured, and that measurement is inimical and central to decisions that are being made for us as a result, or decisions that are being made about us also in some cases. This becomes, when we juxtapose that against the rights framework, where there is a minimum amount of information that is critical to our ability to exercise those rights. That's where the sort of our governance and regulatory systems begin to completely malfunction. In fact, if we think of complex algorithms which are used in everyday use cases, for instance, Google search algorithms are multi-component systems, and even programmers who are working on them, it's completely opaque to them. So another scholar that I would mention here is Jenna Burrell, who's demonstrated very clearly how some of our traditional modes of governing algorithms, for instance, things like code audits, they have been rendered completely futile by machine learning, because the number of auditor hours that would be needed to be engaged to untangle the logic of these algorithms in a complicated software system would be huge. And so if we go back to the Google search algorithm example, even if you had Larry Page and Sergey Brin in this room right now, and you were to turn to them to ask them to give you a recipe of how a search term led to particular results, they would not be able to provide that. So the route that algorithms now take to arrive at a particular conclusion is so circuitous and so dependent on several factors that they're completely inscrutable to human understanding. So, like I said, these algorithms build upon themselves, and the internal decision logic evolves as it learns based on the input data that it is getting. And handling a huge number, especially of heterogeneous properties of data, adds complexity to the code. So that's to set sort of some background for some specific case study discussions that we'll get into. That's the overall sort of data and algorithmic environment that we're dealing with. Right? That technology has emerged in a particular way, and its emergence has rendered untenable, or at the very least, very difficult applications of certain traditional modes of regulation that we have relied on, at least for the past few decades. So now, sort of moving on from general to specific, what I'd like to talk a little bit about is a couple of case studies from India itself. The first one relates to our biometric national ID project called Aadhaar. On May 10, 2018, the Supreme Court of India concluded its hearings in a landmark case with major implications for the Aadhaar biometric project. This case, which essentially began for the very first time in 2012, it took about 6 years for it to get to its final stage of hearings. This case was about the identity ecosystem, and essentially the largest biometric ID system in the world, which involves a 12-digit unique identification number, or what we call the Aadhaar number, generated for every Indian resident using data including iris scans, 10-digit fingerprints, a picture of the face, this is the biometric data that is being collected, as well as other demographic data such as name, address, and few other details. Now, the proponents of this project argued that the new ID number would resolve several issues such as welfare leakages and the lack of access to social benefits for those at the bottom of the pyramid in India. These arguments have been severely tested over the years by social welfare researchers. And aside from that, also, opponents of this ID system have raised questions of inequality, questions of privacy violation, exclusion and discrimination that arises from a system of this nature. The final set of hearings that went on in the Supreme Courts went on for 38 days, over 5 months. And these were the second longest set of hearings in the 70 odd years of the Indian Supreme Court's history. And while this 5 months is a long enough time, like I mentioned, the litigation actually began 6 years earlier, back in 2012. And over the course of 6 years, this started in 2012 with one single petition. And over 6 years, 29 other petitioners were tagged together, and they contested various multifarious aspects of the project, as well as later its legislation, which was passed in 2016. Now, eventually the court's final decision delivered on September 26, 2018. Judges ultimately ruled 4-1 in favor of upholding the Aadhaar program, but with certain constraints. For instance, it cannot be made mandatory for obtaining a bank account or mobile phone, nor for registering, for instance, in the school system. But the aspect that relates to our broader discussion are the technological questions that emerged in this litigation. Now, before we get into that, one of the things that I wanted to highlight was that some of the experiences, for instance, with judicial examination of technological questions in India, what that clearly demonstrates is that because judges don't go through, specific trainings in terms of dealing with these emerging questions of technology, essentially these courtroom hearings are an exercise in capacity building. So you have capacity building via litigation, and they are very much pedagogical exercises where petitioners and respondents are expected to essentially demystify the technological systems that they're talking about so that judges can rule over them. And while there were a range of legal issues, these legal issues in the Aadhaar case very much reside around questions of legislative fact. When I say legislative fact, I mean questions of fact, which must first be resolved in order to be in a position to apply the law to it in any meaningful fashion. So for instance, to give you an example, in an ID system like Aadhaar, the crux of which is how you go about authenticating yourself. If one does not understand how false positive rates work in the context of authentication, how are we expected to apply the legal standard of equality and discrimination, which will then determine whether public use of such a technology is inherently discriminatory? So to give you an example, the biometric report of the UIDAI, the authority that governs Aadhaar, had itself cautioned the issues around biometric authentication for a country like India, where there was a large demographic involved in doing manual labor, which would result in worn out and changing fingerprints over a period of time. And even if in this case, the court was satisfied that the failure rates of biometric authentication are low enough that they don't meet the threshold of discrimination, what the key questions of legislative fact that must be looked at are, for instance, are these exclusions random or are they systematic? And as has been argued in the case of the Aadhaar ecosystem, these failures were not random, but very much systematic. And what this means is that the impact of the failures of technology are not randomly distributed across the population, but systemic and concentrated within those more prone to have worn fingerprints and cracked fingers, for instance. So this is the kind of technological understanding that lies very much at the center of being able to legislate, being able to litigate, and being able to regulate technology. And because these functions have been regulated to certain elite professions only, there is a clear lack of expertise in terms of being able to address them. The other key kind of case study that I would mention here is something that I looked at in detail over the last 2-3 years, was the increasing use of sentiment analysis by law enforcement agencies in India. Now, over the past few years, a number of state and central government initiatives have been announced in India which mandate the analysis of social media data for law enforcement purposes. And there are social media labs maintained by agencies that perform what they describe as public sentiment analysis to identify behavioral patterns, influences, and track the changes and increase in chatter and generate alerts in real time. Now, for the police to be able to take suitable action. This is something that I directly quote from the policy documents that govern these systems. And then eventually the sentiment analysis is intended to generate tags to classify posts and comments on social media in either negative or positive or neutral, as per the National Police mission. Now, the sentiment analysis is not something which is new, or it's been used for a few years with varying degrees of success. So for instance, its most common use is when, as a corporation, I could use sentiment analysis to look at reviews of my products, user reviews of my products, and arrive at marketing strategies based on that. So, and there, the accuracy or inaccuracy of a system of that nature, or the scrutability or inscrutability of a system of that nature, doesn't necessarily have public interest implication. But when the same algorithm is used by law enforcement agencies to make decisions about investigations, or to make decisions about arrests, to make decisions about of public order related decision. So then there are very, very clear implications to right to life and liberty, and consequently also implications for free speech, because they could have significant chilling effects. And so from what we understand about its use in India, the impact of sentiment analysis on law enforcement practices is at the level of both investigations and judicial examination. Now, how insights from such methods are acted upon and how the courts interpret them becomes the key question with regard to our larger discussion on the informed self and the quantified self. In case of law enforcement use of sentiment analysis, if you have to make the decision whether to arrest, whether to investigate further, based on online behavior of speech of specific individuals, and you're relying on computationally inferred understanding of the affect or attitude of those individuals, then any proceedings that the police undertakes, or any proceeding that the judiciary must review, is on the basis of an opaque inferential procedure, and by virtue of that itself should have questionable legal basis. So what we have more and more is technological systems that emerge, and to a large extent, these systems are justified on the basis of some statistical understanding of how accurate they are. But, or even if you look at something like the right to explanation in European Union's General Data Protection Regulation. What the right to explanation simply talks about is when you do use algorithms, when you do use automated processing, all that you must do is to be able to give some information about the general algorithmic logic behind how those decisions are taken. But those decisions in their specific application might have some implication for an individual's rights, right? So how an individual's data is processed, what kind of decisions are made based on that data, based on that personal data about that individual. And the ability of the individual to be able to compute why those decisions were taken. So it could be, for instance, decisions about creditworthiness about an individual based on alternative data and kind of new age models. Why somebody has been denied a loan or why somebody's credit score has gone up or down. If those decisions become completely inscrutable, then that also again relates to the idea of more information, more quantification of individuals, leading supposedly to sounder decisions in that quantified society. But leaving individuals with very little recourse in terms of being able to challenge, question, or even understand sometimes fairly fundamental decisions that are being taken about them. So to proceed, in the case of, for instance, going back to the use of sentiment analysis by the police in India, to proceed in such cases without demonstrable and articulable reasons would amount to acting in what in law we call an arbitrary manner. But unfortunately, that's not how regulatory frameworks often look at these actions, because they often look at broader numbers, broader statistical understanding or justifications for using a new age method. So now with the rise of national ID systems, now in order to respond to this kind of regulatory, both kind of a regulatory vacuum in which some of these technologies operate, as well as the failure of just a rights-based system that we are more and more seeing. What we tried to do was we looked at digital ID systems as an example of technologies of that nature. And we tried to come up with an evaluation framework which articulates the key principles on the basis of which a system of that nature must be measured against, in order to ensure that human rights are adequately protected. So what we articulated was essentially you need three broad categories of tests. First, you need something what we call as rule of law tests. So for instance, emergent technology that has human rights, deep human rights implications of this nature, such as foundational digital ID, must only be implemented along with a legitimate regulatory framework. That legitimate regulatory framework must govern all aspects of digital ID, including its aims and purposes. So what our rule of law principles mandate then is that there must be a governing law enacted by the legislature. That law must be devoid of excessive delegation. It must be clear and accessible to the public. I think the sort of larger problem that we are identifying across these systems is that of inscrutability. And that inscrutability comes from technology, but that also comes from practices of legalese. So that law must be clear and accessible to the public. And it must be precise and limiting in its scope and function. So to take a more recent example, during the ongoing litigation in Kenya on their digital ID system called the Huduma Namba, that was met with criticism, and the court looked unfavorably at the idea of it being legalized through merely a miscellaneous amendment act in that country. And that miscellaneous amendment act, which was generally just meant for small or negligible amendments, being used as a vehicle for such, what even they admitted was supposedly a transformational technological legislation was seen as not kosher. The second kind of tests that we speak about are the rights-based tests, because that's where our discussion begins from. Primarily in the context of digital ID system, because of its collection of personal data and determination of eligibility and rights of users, they intrinsically involve implications for certain fundamental rights. So the use of digital ID for essential functions of the state, right? So whether it is delivery of benefits and welfare, maintenance of civil and sectoral records, these restrictions on, for instance, the right to privacy by greater collection of personal data must be clearly justifiable within a rule of law framework. So accordingly, you don't just look at the legislative framework, but you look at the entire architecture, users, actors, regulators, and those have to be evaluated at each stage for the right against potential violations of the right for those restrictions to become justifiable. And there, I think the example that we can take is from Jamaica, where the National Identification and Registration Act, which mandated citizens' biometric enrollment at the risk of criminal sanction. That was the idea of criminal sanctions against mandating enrollment was held to be disproportionate by the courts. And finally, I think that the key piece of our governance framework is what we call the risk-based tests. So even if you have a valid law, even if you have a law which seeks to protect the rights, the design and use of ID ideally has to be based on an analysis of the risks that the system introduces. And this also again relates to questions of legislative fact that I mentioned earlier. So to give an example, there are design choices that could take the form of choosing between, for instance, a centralized system like Aadhaar, or a federated data storage system like we have in the case of gov.verify in UK, or a system which involves federated collection of data across databases in Estonia. So these are again based on, these are key design choices, and those design choices have to be connected to the overall objectives of the program and in what way can they be most rights preserving. And the other, I think, part of risk assessment that is often ignored by these discussions is that when we speak of risk, we talk of two things. We talk of the likelihood of harm, and then we talk of the severity of harm. In the case of Aadhaar, in the courts, the government argued that the likelihood of harm was so low, based on statistical data presented by them, that the system itself was justifiable. But even in cases where there is a low likelihood of harm, but a very high severity of harm, that could be good enough reason to not proceed with that particular design decision. So for instance, in India, the UIDAI stores the biometrics of all individuals in a central repository. Now, with all security measures in place, one could argue that the likelihood of a breach of that repository is very low, but it can never be zero. Even in the remote chance that that system is breached, the severity of that loss is so high, because if it stores biometric information and that information is breached, then those harms become irreversible, because unlike passwords or unlike credit card numbers, we cannot change our biometrics once they have been exposed. So that is a classic example of, even despite being able to demonstrate a very low risk in terms of likelihood, if even in the remote possibility, the severity of the risk is so high, it may be a bad design choice. So those are, I think, the three key components of a governance framework that we articulated based on the school of regulatory theory that we draw from, which is responsive regulatory theory, where we look at regulations role, not just in terms of legislating around an issue, but to create a system of supports and sanctions that leads to the most favorable outcomes. And I realize that I'm sort of running a little late on time. So the last part of my presentation that I'll quickly bring back in terms of the COVID-19 pandemic is that our framework was then applied by our partners in Brazil in an organization called ITS Rio. And they applied their framework to COVID-19 related apps being used in Colombia, Ecuador, Mexico, Peru, and Brazil. And from that framework, also some very interesting sort of insights about the use of COVID-19 apps emerge. Now, apps in Colombia, Ecuador, Mexico, and Peru operate without any specific legislative backing. In contrast, Brazil's apps are backed by a legal mandate. And while they comply with most rights-based principles from the perspective of privacy, they have serious exclusionary challenges. There are some apps, for instance, which relate to contact tracing, but there are also apps which expand the use cases to things like self-diagnosis, fixing of medical appointments, alerts in case of exposures to infected people. So and even in cases, for instance, in Colombia, users receive free 0 rating internet packs in exchange for registration on their Corona app. And so we see some very, very interesting uses of apps. In Peru, for instance, the app is primarily a contact tracing app. It gathers geolocation data and offers telemedicine services simultaneously. Mexico, again, to a large extent, the principles, some of the internationally recognized principles are a part of the app. So the app can be used without sharing your personal identity information. But there are no clear rules on precisely which actors get access to the data that is collected. So essentially, even as we look at technological responses to the pandemic, whether it is in the form of digital ID systems, whether it is in the form of remote collection of data, remote provision of services, delivery of welfare through technological means, we need to have some of these measures in place. Is it based on the rule of law framework? Are they rights preserving? And most importantly, what is missed by most of these analysis is, are there risks of exclusion, discrimination, privacy harms that the overall design of these systems take into place? And then how do we go about regulating them? With that, I think I'm already 10 minutes beyond the sort of stated time limit. So with that, I'll close this presentation and open the floor for any questions, feedback, comments.
Thank you, Amber. Thank you for your presentation. I was, hopefully you talk about your project with Brazil, because I was asking you about that and I was waiting for that. So maybe in the question we will, maybe people will want to come back on that topic. So I open the floor for question, and to remind you, you write your question in the chat box, the Q&A, and my colleague Celine is going to read your question and ask them to Amber. So I leave the floor to Celine.
Okay, thanks Amber for your very interesting talk. Harsh had already three questions, so I'm gonna ask them in the order they were asked. Which was the last scholar Amber stated in reference to code audit? Maybe Amber, you can say it again.
Sorry, can I ask you to repeat
the scholar? You mentioned a scholar, and Harsh missed the name of the scholar, and it was the one in reference to code audits.
So the scholar that I mentioned is Jenna Burrell, Jenna, Jenna, Burrell. And this is the specific paper that I was mentioning was a paper which was published in an open access journal called Big Data and Society. I don't recall the exact title of that paper, but essentially the argument that Burrell makes is that there are traditional ways in which we have measured code or we have evaluated code. And often what we do is there are ways of testing and conducting audits. And what we try to do is we try to look at what the intended outcome of that code was and to what extent does the code match that. Now, in the case of machine learning algorithm, the biggest challenge is just the size of the code and the fact that the algorithm also keeps evolving itself. So it becomes much harder to sort of decide on a point in time where you will then conduct code audit. And so that was a classic example of kind of the incomprehensibility of modern technologies that render sort of older methods of regulation obsolete.
Okay, thanks. The second question from Arsh is about explainability. And you mentioned the fact that machine learning algorithms lead to unexplainable outputs. And the question is, what are the best governance frameworks around the right to explainability, which one can approach towards?
So when we think of something like right to explainability, we have to think of it in terms of various challenges, right? So you could have a right to explanation, for instance, much like what the European GDPR contemplates, right? If automated decisions are made using your personal data, then you have a right to explanation. But that right to explanation is limited to being informed of the general algorithmic logic of the system that is dealing with your data. So for instance, if that system calculates my credit score and I'm unhappy about it, I can make a request for right to explanation, and it can broadly describe, you know, this is how the decision tree works. This is how these are the factors that it takes into account. But what it cannot tell me is how data about me led to specific consequences for me. And that's where we see limitations in that existing governance framework. The other thing is also that there are various systems where maybe explainability is not as important. So like I said, if sentiment analysis is being used to do a review, do an analysis of user reviews of a product, and then that informs the marketing decisions of a company, then the costs, the decisions are made by that corporation, and the costs of that bad decision, if that is the case, are also borne by the corporation. But when the same algorithm is used by law enforcement agencies, then that decision is made by regulators or that agency. But as individuals, as publics, we bear the cost of it because, you know, because it has clear human rights implications. So when we think of explainability, what we also have to think of is, one, what is the technical feasibility of a right of that nature? So it may be fine to say that, you know, we have a complete right to explainability, but how do we go about implementing it? So in my paper on sentiment analysis, there is a particular framework that I propose, where I say that if public interest decision making is happening, which has an implication for human rights, then the minimum threshold that must be met is what I call retrospective adequation. So even though the algorithms are opaque, what you must be able to do is that you must be able to look at input data and you must be able to look at the final output and see that based on human reasoning, are you able to adequate the reasoning from the input data to the final output. So to give you an example, you have natural language processing algorithms which detect hate speech on Facebook, right? Now that algorithm is based on some understanding of what hate speech law is, and then how do you go about implementing that law in court. But even though I don't understand, as a human on the loop, as a human observer who reviews the implications of that algorithm, even though I don't understand at all on how I went from A to B, essentially an independent review of the decision from A to B can still be done. So that's the model that I proposed, was to circumvent the problem of lack of explainability. And when you meet a certain threshold, you must be required to introduce that human on the loop who does an independent assessment of those decisions. But there are various kind of technological models also that exist for explainability. And I can, there's a recent paper that I and a colleague I wrote with a computer scientist where we try to categorize the different kinds of explainable models that exist. But by and large, their application remains very, very difficult. And the sort of general logic that it seems to follow is that the more explainable you try to make an algorithm, it might have an impact on its supposed accuracy. So it's not a win-win scenario in that sense also. But there may be other ways to get around it. And I think, like one of my colleagues would say, that essentially machine learning and AI are full spectrum regulatory issues. So in some cases, maybe you want to say that we don't have clear explanations, so we will prohibit the use of machine learning. And this must be done through other traditional sources, through other traditional methods. Or there could be cases where you don't have significant rights implications or significant public interest implications. And you might have a principle of complete forbearance for that specific use case also. But yeah, sorry for, I think I went way beyond the remit of that question.
Yeah, and that is interesting. Interesting you mentioned the GDPR, because there is a debate about the right of explanation, and I'm not sure that the GDPR enact a right of explanation, an individual right of explanation, a right of information, which is different. And maybe that's a part of your work about the different kind of explanation and what we really need to know and what we want to know. And that is another point. And the human in the loop is also a part of the debate. But I would like to ask the question of the audience. The last question of Harsh is about the three tests you mentioned. You test with the 3 trains, and the question is to know the different processes, the different steps of this test are about algorithmic impact assessments, human rights impact assessments, and data protection impact assessments, respectively, for each branch of your test.
So impact assessment relates very clearly to the third leg of the tests that I mentioned, which were risk-based tests. So the key problem that I tried to highlight there was that even when you have a legislative framework, which fell under what I call the rule of law tests, even if you have rights preserving or rights protecting legislative framework, which would fall under the rights-based test, often what happens is that there are several kinds of both intended and unintended consequences of the uses of technology, emergent technology, because being sort of fairly multi-purpose technology, they have fairly far-reaching implications as well. So there, the idea of impact assessment clearly aligns with what we also try to propose, that both at the beginning of embarking on these projects, on these initiatives, as well as these sort of models, whether it is in the form of data-driven decision-making by government or data-driven business models from private sectors, as they emerge, the need to do impact assessment based on a variety of factors. So I think you mentioned data protection impact assessment, you mentioned human rights impact assessment. I think there was another kind of impact assessment also that you mentioned.
Algorithmic impact assessment.
So from all of these perspectives, the idea of being able to do risk assessment is very much aligns with that. And essentially, in all of those categories of tests, there are specific questions that we pose. And currently the model was created specifically for digital ID framework. But the idea was that this is a model that we want to kind of reinvent for other forms of emergent technologies also. So in the case of ML, what we want to do as we're going forward is to articulate these tests in the form of very, very specific questions that can be asked of an algorithmic system, and their algorithmic impact assessment and data protection impact assessment becomes very important. So I think because we are not thinking of the various outcomes and consequences of these technological systems, what we are finding ourselves in positions is that the regulatory threshold is, the regulatory framework is also constantly trying to catch up. By the time you are able to think of a regulatory framework, by the time a regulator steps in, it is often, the harm is done, the consequences have already been manifold. So it is our belief also that drawing from the idea of risk assessment, and what is encouraging is more and more we see impact assessment and risk assessment gaining currency, at least in data protection legislation. And from there, I think even in things like competition law, antitrust law, and consumer protection law, gradually will seep through. So that's a broad trend. If one goes through the framework itself, you'll be able to identify specific questions within each test, and some of them relate to impact assessment. But right now the framework is only created for digital ID systems, so you may not be able to find all suitable tests specifically for machine learning or AI.
Thanks, Amber, and Harsh is. Thank you as well. I still have 4 or 5 questions, so maybe you should answer more quickly or more shorter. Thank you. Kai Hinch asks you if you could share more about the implications as we transition into the quantified self for workers and in hyper-surveillance, and are its implications in terms of worker-employer relations?
So I think what more and more what we're calling as Industry 4.0, and I think artificial intelligence and ML is only a small part of that phenomenon. But there are various aspects of it which have very, very clear implications for worker rights as well as for workers' welfare. So more and more, for instance, we did a lot of study of automotive technologies in India and how the automobile sector was evolving in response to Industry 4.0. And there, some of the things that we noticed was that there is increased surveillance of workers, there is increased reliance on specific kinds of automotive machines, which also cut out certain kinds of tasks. So while this whole sort of dystopian idea of machines kind of taking away our jobs might still be fairly far off. I think a lot of literature on that seems to suggest that a lot of it is well, I won't say made up, but it's not in the immediate offing. But what we are very clear on, while machines may not take away jobs in the near future, they are definitely reorienting and changing the nature of jobs. And jobs are, so jobs in factories, jobs in terms of delivery personnel, and to what extent their movements are monitored. We definitely see a trend of surveillance and of a form of working that leads to more and more dissatisfaction. And then there were already existing trends of business models built around technological companies which denied basic rights to workers by creating contractual arrangements in particular ways, where benefits were not accorded because workers were considered often not employees but as on a contract basis. And I think with the introduction of technology, we will see an even more amplification of those problems. So surveillance is going to remain a huge issue as we adopt more automotive technologies, or we adopt more, and we see more application of Industry 4.2.
Mm-hmm. And Arshit asks, what are the key challenges the Indian state faces that stand out in comparison to global challenges to regulate online harms? Interesting question.
I think a lot of various kinds of problems that we are facing in India are, I think, reflected in other jurisdictions also. But I think what happens is because of the scale, because of the population of the country, often the scale of these problems becomes quite unmanageable. So even with regard to, for instance, the ID system, even a small failure in the technological system can lead to, for instance, exclusion of very large parts of the population. Similarly, when we're looking at, for instance, the implication, since you mentioned online harm specifically, if we look at content regulation and things like that, there is a fair bit of targeting through misinformation and hate speech that is happening in India. And I think in the way that it is perhaps different from a few other countries, but maybe similar to countries like Brazil and China, is the use of WhatsApp as opposed to social networking platforms like Facebook and Twitter for the spread of misinformation. And as end-to-end encrypted system, it becomes even harder to regulate them. So that's those are some of the ways, I think, in which, to give one example of a different kind of challenge that the Indian state and Indian regulators face.
Mm-hmm. Thank you. Jean-François asked you about a question about the 3 steps, and he asked if we should apply the 3 steps before using a new algorithm or an app. But the way an algorithm concretely impacts a context is often impossible to foresee. So considering that, he asked you if it would be an iterative process.
Yes, so in a clearly identified technological system, it's a little easier to apply those tests because at least you have clarity on what that system is, what it is intended for, what its uses are, who are the actors who will use it. But in terms of a general technological system, for instance, specific algorithms that might be used across industries, across sectors, it becomes much harder to apply that. So there, I think it's important to then see, so the thing that I spoke about was to articulate thresholds for regulation. So when those thresholds are met, and there also, I think in a separate paper, we came up with 4 tests with regard to artificial intelligence specifically, where we said that if it relates to use of personal data, if it relates to a dichotomy between who is impacted by that technology, whereas who is making decisions about that technology, and whether it relates to whether you have means of doing retrospective adequation. When you meet those thresholds or more than 2 of those thresholds, then perhaps at that point regulation needs to kick in. But that is a complicated regulatory question, that when do we start doing these assessments? When should there be preconditions? When should they be deployed and then come as at a later stage? And I don't think there are any easy answers to that.
Mm-hmm. And the last question is about the fact we should consider as a public interest, we should consider data, machine learning models and outputs as public goods, and in order to maximize public interest. Should we consider this as public goods?
That's a complex question. So particularly in countries like India, the Indian state, for instance, has put out a regulatory framework called non-personal data. They claim certain rights over data that is produced by the Indian population, for instance. So it's a complex question. A lot of that emerges from, I think, clearly some anti-competitive practices that we see in the digital technology domain, where certain big tech companies, where a handful of big tech companies have a larger control over this data ecosystem, and they have very high, and there are very huge barriers to entry in that sense. But to equate that to say that it should be considered as public good or public resource is not easy to answer. So if we think of natural resources of certain kind, we've had PSNR rights around that, where we said that natural resources, there are indigenous populations who have the first right over it, and they are sovereign in terms of controlling it, and that's not something that you can contract out. To apply a similar standard to data becomes more complicated, because data inherently involves participation of multiple actors, right? So there are individuals who might be involved when we talk of personal data or anonymized data. Then there are often, apart from individuals, there are group rights and community rights that are involved. Then there are private sector innovations, private sector processing of data, private sector inferences made from data, where the data processors are involved. And then obviously, more and more we're saying the state kind of flexing its muscle and saying that there is certain rights that it has over, for instance, other states when it comes to data of its own citizens. So it's a complex idea to navigate. And one of the things that we're trying to do is to see if there are any kind of legitimate beneficial interests that we can identify for different stakeholders and how they might interact with each other. But I think it would be too simplistic to say that algorithms or inferences or public or data of that nature must be considered as public goods, because then it also, the right to privacy is not an alienable right. So there are privacy implications, there are community rights implications, there are also, in some senses, some trade secrets or other intellectual property or intellectual labor implications. So it's a complex web of things, and we need to kind of see how those different interests conflict with each other, and then it's a question of resolving those conflicts.
Thanks for your answer, Amber. And I let Karin conclude this conference. Thanks, Amber.
Thank you, Amber, and yeah, very interesting. And thank you for the question from the audience. We should have more time and maybe more questions, but we have to close now. I want to thank Amber for his time. It's late for him. It's 10 p.m., so it's a long day and a long presentation. So thank you for being there for us and for your presentation, and very interesting point you've made. For people who are interested, they can visit the CIS website. I think a lot of your papers and the document you talk about are on your website, very well accessible, and it's you can download, I think, most of your papers, so it's very interesting. And the website is very interesting, and it's a lot of information. So I invite you to go on their website. So in the name of our audience and Celine and I and the observatory, I want to thank you, Amber, for your time, for your presentation, and we keep in touch, and I hope we will have another opportunity to work with you and with your center. So thank you, everybody. Have a nice end of day and end of evening for you in Bangalore, I guess. Okay.
Thank you.
Thanks.
Pleasure.
Thank you. Take care. Bye, everybody.
Thank you. Bye.